There's an old saying, oh, what a tangled web we weave when first we practice to deceive. Y'all have heard that before. It applies to everybody in this case. I think Mr. Tootle deceived himself when he thought that he was going to be able to marry this lady and fix her problems and that they would live happily ever after. Although he admits today he thought maybe he only had a 50-50 chance of success in doing so. Of course, Ms. Balknecht has testified that, or at least there was testimony that, I don't think she testified about it, but there was testimony that she didn't realize that she didn't really love him until her therapist, I think it was, that told her she didn't really love him. And if she went out and had sex with two other men during the marriage, obviously that would be something that she didn't marry. She did love him. So this is a situation that is a temporary hearing that is designed to keep the parties in life and limb together until such time as they can conclude this matter after discovery and after mediation takes place. They are both asking for a divorce. So therefore, as was pointed out, whether Ms. Balknecht wants to move out of the house or not, right now, that's coming. I mean, you're going to have to do it sooner or later. Mr. Tootle has indicated that he cares for her children, and his concern is that she may make some false allegation against him while they're continuing to live together. So it's going to take time for her to move out. The Dixon County school system concludes the school year on what, May 23rd, I think it is?
Yes, sir.
And it is this court's opinion that these parties will continue to cohabit in the marital residence until June 1st. At that point, Ms. Balknecht will vacate the property. Mr. Tootle will continue to have temporary possession of the marital residence. I make that statement because of the fact that it is apparent that Mrs. Balknecht cannot afford to pay the house payments, and therefore if he is forced to leave, he's going to still have to make the house payments. She has indicated that she wants to sell the house, which obviously indicates she would then have to leave. In the interim period that they reside together, she will pay all payments that she has on her income and expense statement. I have added, she's showing a shortage of her income and expenses that she's negative $1,505.56. If you add back in the child support payments and her renewable income, then that comes to $5,978.46. So it's clearly more than her expenses are, even considering those expenses, which when I look at, no, and I don't mean this to be harsh, but I don't spend $489 on recreation and entertainment a month. Clothing and personal care, $400 a month. Folks, you're going through a divorce. You're going to have to tighten up a lot of these expenses that are otherwise you might do if you're living in a nice home and having two incomes that total over $200,000 a year. This is not going to be the case. Short-term marriages that go through divorce, the court's usually looking to put the parties back in the situation they were in prior to the marriage. It's just that simple. Short-term marriages of a 6-month do not typically require or even justify the awarding of alimony or spousal support, absent some compelling circumstances. So I'm just saying these expenses that are here are going to have to be looked at. Her car payment of $1,034.27 is fixed. It's going to have to be paid. She's got cell phones for a 10-year-old, so be it. She'll have to pay for it. Her automobile insurance goes with her car. Her food and groceries are $1,200 a month. She's only going to be required to provide food and groceries for her and her children. He will have to provide food for himself. Laundry and cleaning doesn't seem to be particularly outrageous, but the $400 for clothing and personal care and $489 recreational entertainment may be an area that Ms. Balknecht has to kind of reduce. Mr. Tootle will be required to pay those expenses that are shown on his income and expense statement. Right now, he's paying the house mortgage. He wants to keep the house. The issue of any credit that he is to receive for making the payments on a temporary basis, any increase in the equity that might result from that will be reserved for the final hearing. In this case, he's providing right now for the next 2 months at least a place for her and the children to reside until June 1st. And that, in my opinion, would justify that. I've taken away the $300 phone bill that she's now going to be required to pay, which means he'll have some small amount. But I also think he's got a greater amount than what's shown on here because there's some flexibility in his income. In any event, he'll pay the monthly mortgages on the house and all of those other bills that he has paid, with the exception of the Chevrolet Tahoe, which she is going to be required to pay. And with that being the case, I will put down this further order. These parties are both restrained and prohibited from involving law enforcement in any way, shape, form, or fashion against one another to gain an advantage in this divorce action, or to seek to have the other removed from the home. A violation of this order will be contempt of court. I'm just simply saying that. I'm not saying you would do that, but I'm saying there's been some allegation that you were going to call the police. There's some reason he might, but I'm simply saying you can't do that under this order. And as a result of that, if something happens and it turns out that somebody violates that order, they're looking at 10 days in jail for even doing that, making that type of report. If there is any indication of violence in the home, you must come to this court, file an application for an order of protection with the Chancery Court of Dickson County, Tennessee, so you will have that protection. And if you feel threatened or you have the right to apply to this court for an order of protection. They will present it to me personally for me to review, since I'm the one who's hearing this case, and I'll determine whether or not there is a need for an order of protection, and then probably would have to set a hearing even if I denied it. So both of these parties are restrained and prohibited from arguing, fussing, fighting, speaking negatively to each other, cursing each other, certain words that are just not acceptable. And you've uttered one of those in regards to your wife. Whether you agree with what kind of a life she's lived in the past or what kind of behavior she's exhibited, she is your wife. She deserves more respect just for that fact alone. And he deserves, being your husband, to have a little bit more respect than what you've shown him. So treat each other with respect in this time you live together. Either of you has the right to vacate the home upon your decision to do so. You can move out and let her have the house pending that. She can move out if she doesn't like living there with you. But you're going to cohabit it peacefully. There will be no fussing, fighting, cursing, or anything else. You'll reside in the upstairs bedroom. She'll reside downstairs. There will be no damage inflicted on this house by anyone associated with that. So both sides are prohibited from destroying, damaging, or whatever. You are prohibited from allowing your 10-year-old to drive the car. At least at this point, just don't let him drive the car. Don't let him shoot holes in the wall with a bow and arrow or whatever it was that was there. Just be no damage to the residents. Absent an agreement otherwise, I'm going to order that there be an appraisal conducted on the value of this house to determine. I know that wasn't necessarily requested, but it goes with the question of selling. Let's find out what the house is worth. It may be worth considerably more, in which case you may have a lot of equity that you may be entitled to. You maybe have lost in the downturn of the economic market that real estate has suffered recently. It may be worth less. So as a result of that, we're going to order that the parties agree upon, unless you have some...
Chris Chatham.
I was just about to utter those words. Chris Chatham would be the person who usually does the appraisals in this area. You have any objection to that? Chris Chatham will be authorized to perform an evaluation of the house. And then the issue of we'll reserve the issue of selling the house. If there is substantial equity that Mrs. Balknick would be entitled to, then it may be necessary to sell it. Mr. Tootle, you have exhausted all of your equity, but the court will reserve the issue of your contribution of separate monies in the determination of how any equity in the home is to be divided. So obviously, if there's no equity above the separate contributions, then it may make sense to award it to him, and he's simply eats whatever the loss is of his equity. But otherwise, that's the order of the court. Mrs. Bachneck's mother and is going to continue to reside there to help her with the children. I don't want any questions raised about that. You seem to like her and get along with her. If you two will treat each other with kindness and be sociable and civil to one another, then you can coexist until the time for this to be resolved. And hopefully by the end of May and the first part of June, you all will have been able to determine some of these issues, and maybe you can resolve this and go separately and start your life over again. Seems like that's probably where both of you are headed. So sometimes the fantasy we have about how great things are going to be just doesn't work out. And that's, I think, where we are right now. So I think both of you are looking to gain something out of this situation, and unfortunately it's not going to work out for you. So we're going to end your divorce. I noticed that it's been pending now for less than 90 days, but it's been pending more than that. So you two talk about whether or not you want to go ahead and finalize the divorce itself. So if you want to talk to your client, if she wants to go ahead and be divorced, I can pronounce the magic words today and grant you a divorce. If you want to think about it, then do so, and you can let me know.
We would prefer that, Your Honor, so that any rights of
I'm not going to
inheritance.
do it unless both sides, since it wasn't requested and it's not a final hearing, the only way I'll do it is if both sides desire to have the marriage terminated. The advantage to it is that it fixes the date of the marriage so that we know what the contributions are to each other. But it may be that Mr. Odle and his client don't want to do that. Y'all talk about it, and you can always let me know before today is over what you want to do. All right.
Thank you, Your Honor.
Mr. Roberts will draw the order and submit it to Mr. Odle for his approval.